say welcome to everyone who is joining us on this cold Tuesday evening for this webinar titled Privacy and Protection, the use of covert recordings in family proceedings and withholding notice of proceedings from abusive parents. That, as you probably know, this is brought by the Garden Court Family Law team. And I would just like to explain that you will be hearing from, firstly, from Laura Williams, who will explore withholding notice of family proceedings from fathers, explaining the competing rights and interests involved in those applications. You then hear from William Tautz, who explores the legal and evidential and practical issues and examines the consequences arising from the use of covert recordings by parents in families proceedings, and which will be is all more and more relevant in now day of modern age of at the ease of recording things. Just to give a brief background, Laura Williams is a barrister in Chambers. She specialises in public law cases, represents all parties in care proceedings, deprivation of liberty and secure accommodation and adoption proceedings. She has a particular interest in representing neurodivergent parents and children whose needs are often misunderstood or ignored. Laura has experience of care proceedings with an international element also, placing children outside the jurisdiction and potential transfers of proceedings. And then, as I said, you'll also hear from William Tautz. He is a family law specialist. He practices in both public and private children's law, including care, adoption and international cases and deprivation of liberty. William acts on behalf of parents, children mainly, undertakes some of the most complex and serious cases involving serious allegations of sexual abuse and physical harm. William is, as all of us are, committed legal aid lawyers who continue to undertake publicly funded private work and children's law cases that involve complex issues. So I would just like to now hand over virtually over to my colleague Laura Williams, who's going to start this evening's seminar.
Thank you. Thank you, James. Hello, thank you for joining us this evening. I'm going to be covering the interesting and important topic of applications to withhold notice of proceedings from fathers. These applications engage fundamental principles of family law, the right to family life, the fairness of the proceedings, both in terms of giving a father a voice in crucial decisions about their child's upbringing, and also ensuring that a victim of abuse can participate in those proceedings without fear for her safety or fear for the safety of her child, of their child. So I'm going to be speaking for about, I think, 30 to 40 minutes in total. And if I might have the first slide, please. Give you an idea about what I'm going to be covering. I'm going to begin by looking at the procedural rules governing party status for fathers and the rules about giving fathers notice of care proceedings. Then I'm going to spend some time looking at the guiding principles and the factors the court will consider when deciding whether to grant an application to withhold notice of the proceedings. Total exclusion of a father, particularly a father with parental responsibility, is extremely rare. That will be reserved for the most extreme cases. In most cases, where there are risks attached to the father's involvement in the proceedings, the court will consider whether those risks can be managed. So I'll consider the sorts of orders that can be made, drawing on the court's extensive toolkit of case management powers to manage risk. In some cases, not many, but in some cases, the courts will require the assistance of an advocate to the court. So I'll talk very briefly about when that might happen and the role of the advocate to the court. And then lastly, in a case where the court decides that the father is not to be notified of care proceedings, I'm going to address how that decision collides with the local authority's statutory duties to consult parents of looked after children before making any decision about their care, and what application the local authority can make to resolve that conflict. Next slide, please. So the procedural rules are probably very familiar to you. Fathers with parental responsibility are automatic parties to public law proceedings concerning their child. Fathers without parental responsibility are not automatic parties. They are entitled to be notified of the proceedings. So they will only receive the notice of the proceedings, no other papers, at the outset of the proceedings, and the notice should be served on them by the local authority before the first listed hearing in the proceedings. Now, the court has a general discretion to dispense with service, but it will only exercise that power, as I've said, in highly exceptional circumstances. Complete exclusion of a father is rare. It will be reserved for those cases where the risks are so serious that they cannot be mitigated or managed by the court's case management powers. Next slide, please. I've set out here some typical reasons why an application might be made. It's not intended to be an exhaustive list, just some grounds typically put forward in support of the application. The first example is that father's never been involved, not shown no interest in the child. So essentially that argument is that father knows this child exists, but there's no family life between child and father. So the court will inquire into the nature of the relationship between the parents. Were they in a relationship before the child was conceived? Did the relationship continue after the child was born? Did the parents live together? Was the father involved at all in the child's care and upbringing? Has the father demonstrated any interest in the child? Has he demonstrated any commitment to the child? For example, has he sought contact? All of those factors, and again, that is not an exhaustive list, but all of those sorts of factors will point towards or away from the existence of family life. And family life is a factor that carries a great deal of weight with the court in these applications, but it's very unlikely your client's application will succeed on this ground alone. It's much more likely to be a combination of this and the next argument, which is mother may say that she is fearful of the father's involvement in the proceedings because there has been a history of abusive behaviour, and she is fearful of further abusive behaviour from father if he becomes aware of the proceedings and the involvement of the local authority. So she will, of course, need to produce evidence of that abusive conduct towards her. And there may be local authority records to support her chronology. For example, she may have had to move once or a number of times to flee the abuse, and the local authority may have been involved at those times. The local authority may also have been involved due to police referrals. There may be other evidence of police involvement, convictions of the father for violence or abusive conduct towards the mother or other partners. And another piece of evidence may be that mother has obtained a non-molestation order in the past, and the evidence in those proceedings will also be relevant to the mother's application. A much more unusual ground is mother's husband is not the father of the child. That's an unusual reason for making the application, but there are some reported cases on that basis, and I'll just touch very quickly on one, a case called Re AB in 2003, and in that case the couple had been married for 20 years and they had two children already, a 7-year-old and a teenager from that marriage, and then the wife fell pregnant and concealed that pregnancy from her husband and from her older children. And she said that that child was conceived as the result of a rape perpetrated by an unknown man who she met casually while she was on a night out with friends. she went to the local authority at a very late stage in the pregnancy and asked the local authority to arrange for the baby to be adopted when baby was born. And when the baby was born, she left the baby in hospital the day after she was born, and then the local authority placed the baby in foster care and then issued care proceedings. Now, the mother opposed her husband being notified of the child's existence and of the proceedings. She claimed that he wasn't in fact the father. As I've said, she explained what the circumstances of the conception were. She claimed that he'd had a vasectomy some 7 years earlier, and there had also been no sexual relations between them at the time of the conception. So now, husband was, of course, an automatic party and had parental responsibility by virtue of his marriage to the mother at the time of the baby's birth. So the mother's case essentially was, first of all, in fact, he could not be the father because of the vasectomy, so the presumption of legitimacy could be set aside. And secondly, that the court should exercise its discretion and refuse to notify husband because of other factors, including previous and anticipated future violence and disturbance of the established family unit. Now, essentially, in a nutshell, the judge at the first instance was not at all persuaded that the mother was giving a full and truthful account of the relevant events, and her application was refused. And then there was appeal, and the appeal, which was described as hopeless by the Court of Appeal, was dismissed. But that's just an example of a case where the argument was husband wasn't the father. And then lastly, father is unaware of the existence of the child and mother fears his reaction and or the reaction of the wider family or community. That's quite common for that to be a reason put forward where the mother wishes to relinquish the baby for adoption without notifying the father or his family of the existence of the child. But whatever the basis is for the application, the onus will be on the parties seeking to withhold notification to demonstrate that there is a compelling case. Now, if your client's in the PLO process with the local authority, assuming your client's the mother, you should alert the local authority at that stage to this issue. And if the local authority then goes on to issue care proceedings, you should make the mother's application as soon as the case is begun. If you represent the local authority and the mother has raised this issue, it would be prudent to flag the issue on the application form on the C110A, and also flag on the application that some consideration should be given to the level of judiciary that should be allocated in light of the mother's intended application. Could I have the next slide, please? So how will the court approach the application once it's made? The starting point was encapsulated by His Honour Judge Bellamy in the case of Re-X in 2017. And he said the starting point must be twofold. First, it will normally be in the interest of the child that her birth father should receive a copy of the form C6A, thereby enabling him to apply for party status so that he can participate in the proceedings. Second, that the child and her mother should not be put at risk of harm as a result of seeking to engage the father in the proceedings. It is a matter of balance, and that is the case, whether or not the father is entitled to the protection of Article 8 and Article 6. Next slide, please. The existence of Article 8 rights are not determinative of the issue, but where father has strong family ties with the child, that will weigh heavily against withholding service. So the court's approach will be to treat the maintenance of confidentiality in such a case as highly exceptional. But exceptionality is not in itself the test, and that is a principle that was underlined by Lord Justice Peter Jackson in the case of Re A, B and C 2020 Court of Appeal decision. Exceptionality is not in itself a test or shortcut. Rather, it is a reflection of the fact that the profound significance of adoption for the child and considerations of fairness to others mean the balance will often fall in favour of notification. But the decision on whether confidentiality should be maintained can only be made by striking a fair balance between the factors that are present in the individual case. Next slide, please. There is no single test for distinguishing between cases in which notification should be given and cases in which it should be withheld. The way the court will approach the application is to conduct a balancing exercise, weighing all the competing interests at play. I'll go into this in a bit more detail in a moment, but at this stage, I think what's important to appreciate is that each case is unique and the outcome of the application will depend on the facts of the particular case. Next slide, please. The court is not determining a question in respect of the upbringing of the child. So the welfare of the child, whilst it will be an important consideration, is not the paramount consideration. Moving on to harm and risk, there's no requirement that a significant physical risk be demonstrated. The case law has established the principle that harm and risk come in many guises, and that's something that was underlined in this case, Bury Metropolitan Council and MLLN, when Mr. Justice MacDonald held that the court's task is to identify the nature and extent of the harm in contemplation. The court should be rigorous in its examination of the risk and gravity of the feared harm. The court must be satisfied that the child is likely to suffer harm in the sense of a real possibility that cannot be sensibly ignored, having regard to the nature and gravity of the feared harm and in the particular case. Next slide, please. The 2020 decision, Re A, B and C, notification of fathers and relatives. This is the seminal modern authority on this issue. There were 3 conjoined appeals involving mothers who had concealed their pregnancies and did not want the fathers and other relatives to know of the births. And in 2 of the cases, the mother had sought to relinquish the baby for adoption. The question that arose in each case was, should the local authorities and the court notify the fathers or relatives before plans for the children's futures are made and put into effect? And Lord Justice Peter Jackson reviewed the authorities and extracted all the relevant factors which are equally applicable to care proceedings as well as relinquishment for adoption scenarios. And he listed the relevant factors in the judgment, which I'm not going to go to in detail, but I would recommend you read the judgment to understand the detailed rationale underpinning each of these factors. So parental responsibility, the fact that a father has parental responsibility by marriage or otherwise entitles him to give or withhold consent to adoption and gives him automatic party status in any proceedings that might lead to adoption. Compelling reasons are therefore required before the withholding of notification can be justified. Article 8 rights, whether the father, married or unmarried, or the relative have an established or potential family life with the mother of a child, the right to a fair hearing is engaged and strong reasons are required before the withholding of notification can be justified. The next factor was the substance of the relationships. So I've already touched on this earlier, but aside from the presence or absence of parental responsibility on of family life rights, the court will make an assessment of the substance of the relationship between the parents, which will include the length of the relationship between them, the circumstances of the conception, whether they were in a committed relationship at the time, the significance of relatives, and whether extended family are close to the parents or distant. Next slide, please. Oh, thank you. The next factor in the list, the likelihood of a family placement being a realistic alternative to adoption. So how likely is it that a family member on the father's side may or may not be a potential carer, where the family placement is unlikely to be worth investigating, or where notification may cause significant harm to those notified? This factor will speak in favour of maintaining confidentiality. Anything less than that, and it will point the other way. The physical, psychological, or social impact on the mother or on others of notification being given, where this would be severe, for example, because of fear arising from rape or violence, or because of possible consequences such as ostracism or family breakdown, or because of significant mental health vulnerability. These must weigh heavily in the balancing exercise. On the other hand, excessive weight should not be given to short-term difficulties and to less serious situations involving embarrassment or social unpleasantness. Otherwise, the mother's wish would always prevail at the expense of other interests. Cultural and religious factors. The conception and concealed pregnancy may give rise to particular difficulties in some cultural and religious contexts. These may enhance the risks of notification, but they may also mean that the possibility of maintaining the birth tie through a family placement is of particular importance for the child. May I have the next slide, please? The availability and durability of the confidential information. Just a quickly go into this one. So in the context of a mother who wishes to relinquish her baby for adoption, she might be persuaded into identifying the father, but she certainly can't be coerced. But if she doesn't reveal who the father is, then obviously notification can only happen if there is someone to notify. But where the father is identifiable, and paternal relatives may also be identifiable, there's a valid question to be asked about whether any confidentiality can realistically be preserved. I will tell you very quickly about a recent example of how these sorts of factors might play out in practice. There's a recent decision of the court in a case called London Borough of Ealing, an X, Y and A 2025 decision. Care proceedings, there were very serious issues of domestic abuse between the parents. The mother was undergoing a parenting assessment with the baby in a residential unit. The father was named on the baby's birth certificate, had PR therefore. Mother and father were in a relationship during the early months of the baby's life. He was then incarcerated. According to mother, he last saw the baby when the baby was about 2 months old. Mother made an application to withhold notice of the proceedings from the father on the basis that if he knew about the proceedings, that would likely increase the risk of harm to her. she filed a statement in support of her allegations that she had been subjected to domestic abuse by the father. Now, the father certainly knew about this child's existence and had expressed to the local authority a wish to be involved with the child's life, and he clearly had some understanding of the local authority's involvement. So overall, the court took the view that that meant he could become involved in the proceedings at any point. Ultimately, the court decided that there was a compelling case for notifying the father, and he should be notified. And what they described as the countervailing factors, or the factors that pointed against the risk factors, could be appropriately managed to successfully reduce the risk to a low level. Then the next factor, impact of delay, and any other relevant matters. So essentially, the task for the court is to balance all the fact-specific features in every case, and then come to a view about whether the risks can or cannot be managed. Could I have the next slide, please? In rare cases where complete non-notification of father is contemplated, the court may seek the appointment of an advocate to the court. And that will be done through inviting the Attorney General to intervene. And that's exactly what happened in the case of a local authority MB dispensing with service. Mr. Justice MacDonald held that consideration should be given to inviting the Attorney General to intervene in respect of the application in circumstances where the party concerned is not, for obvious reasons, before the court to argue the contrary case. Now, in that particular case, a local authority MB, the local authority notified the Attorney General of the proceedings and the application to dispense with service on the father, and the Attorney General indicated by correspondence that she did not want to intervene. But in a case where the Attorney General does accept the invitation, an advocate to the court will be appointed. Now, the advocate to the court is not a party to the proceedings. Their function is not to represent the absent father. Their function is to help the court by providing a neutral analysis of the issues and the law, and to put forward the arguments that the absent father would otherwise have made. And then the other case reference I've included on this slide, REA, Father Knowledge of Child's Birth, I've just included here for the sake of completeness, in case you are ever involved in a case where the advocate to the court is appointed, and then there is an appeal. There is a suggestion for best practice put forward by Lord Justice Thorpe in this case of REA about how the advocates for courts could be usefully involved in the appeal proceedings. Next slide, please. The contemporary judicial approach to this issue, withholding notice from fathers, is that complete exclusion of a father is reserved only for those cases where the risk cannot be safely managed. That risk versus participation analysis was expressed by Mr. Justice MacDonald in Bury Metropolitan Council and ML and LN, when he said the starting point is that a father should be able to participate in a wide sense in proceedings concerning his child. The court should start with full participation, then consider partial participation, and then only as a divisive last resort, the father's exclusion from the proceedings. So bringing all of where we've got to so far together, it's a two-stage process. Step one, the court assesses the nature and gravity of the risks. Step two, the court considers, can the risks be effectively managed through the court's extensive case management powers, often referred to as the procedural toolkit. It's only in cases where the risk is so severe that it cannot be mitigated by the court exercising its case management powers that the high threshold for non-notification will be met. And that was the view expressed by Lady Justice King in Re S. In my view, the presumption in favour of a father being joined to the proceedings should not be displaced if the concerns of the other parties can be properly mitigated by the court making use of the extensive toolkit now available to it in the form of its general case management powers and its powers in relation to vulnerable parties. Next slide, please. So here are some examples of how the court might use its case management powers to manage the father's participation in order to mitigate the risks. Taking a staged approach. So that would involve providing the father with notice and requiring him to indicate within a given period whether A, he seeks to put himself forward to care, B, whether he will be seeking contact, and C, whether he puts forward any third parties. Then depending on the response, if any response, the court can consider disclosure on a redacted basis consistent with the answers to those questions. Now, of course, the court can direct that the father is to be provided with a highly redacted level of information. The usual aim of that is to maintain the confidentiality of the mother's address, her general location, any details which might enable her location to be discovered. That is only going to provide a solution where it can be done in a way that is meaningful and does not create a risk to the mother. The court could direct that documents are to be made available at solicitors' offices rather than sent directly to the client, to the father. That might be appropriate where there's a concern about onward disclosure. The court can require father to attend hearings remotely. The court can, of course, make participation directions for vulnerable witnesses. Examples, screen in court, screening mother and father from each other, separate waiting areas. Next slide, please. If there is any evidence has to be given, the abuser shouldn't be able to directly question the mother, and so the court can direct the use of qualified legal representatives in that case. And then the last point in this list actually really falls into a different category where the court has rejected the mother's application to withhold notice. And that means the father's going to be told about the existence of a child he didn't know existed. The local authority may be asked to help the family to manage that sensitive disclosure. So in the case of Re AB that I mentioned earlier, where the mother had kept the baby's existence a secret from her husband and her older children, and had failed in her applications to withhold knowledge of the child's existence and of the care proceedings from husband. Husband had to be served with notice of the proceedings, and the Court of Appeal, upholding that decision on appeal, looked to the local authority to provide professional support in breaking the news to the family and in managing the aftermath. Next slide, please. Finally, we come to this topic, which I will very briefly touch on, how the issue of non-notification of fathers might collide with local authority duties to consult parents of looked after children. So I've set out here the local authority statutory duties under Section 22 and Section 26 of the Children Act to consult parents before making any decisions about looked after children, and to give due consideration to parents' wishes and feelings before making decisions about looked after children. So where the courts decided that notice of proceedings should be withheld from a father and the child becomes or is looked after, the decision to exclude the father from the proceedings is very likely to conflict with these statutory duties. So in other words, if the father is unaware of the existence of the child, he will certainly become aware as soon as the local authority approaches him to consult him, as they are obliged to do in accordance with their statutory duties. If the father's unaware of the involvement of the local authority with the child, he will certainly become aware as soon as the local authority approaches him to consult him, as obliged to do so in accordance with the statutory duties. So in short, the solution in an appropriate case would be for the local authority to seek a declaration under the inherent jurisdiction, but they are not required to consult the father. And the High Court can grant an injunction to stop the local authority from informing fathers of matters relating to his child. Thank you very much. That's the end of my presentation.
I think that means it's my turn to give you a talk about the recent Family Justice Council guidance on covert recordings in children's proceedings. So if I could have the first slide, please. That is the guidance. That's what it's called. It's specifically in relation to children, and we've given you the link. So what was the impetus for this guidance? Well, it came out in May of this year, but the impetus really starts some time ago in 2017, when the Court of Appeal had before it an application for permission to appeal from a litigant in person parent, which was essentially a hopeless application for permission to appeal. But what the Court of Appeal judge who was reviewing that application noticed in the transcript of judgment was that the judge, the first instance judge, who happened to be His Honour Judge Bellamy, who Laura cited as being quoted with approval by a higher court. In this case, he was not quoted with approval, because what he had done in the first instance decision he made was to attempt to give guidance, which he shouldn't have done. He was sitting as a circuit judge, and really guidance decisions should only be made with the agreement and support of the president of the family division. So Judge Bellamy got quite a ringing slap on the wrist for that one. But the president, Sir James Munby, specifically called for the Family Justice Council to provide guidance on covert recordings in children's proceedings. He noted the ubiquity of recording devices in this modern day and age. He said that in 2017. Most of us have had, phones on our cameras for about 20 years now. So once again, the law is very much behind the times, and as we'll see in relation to so-called deep fake and AI-generated technology, it's probably still behind the times. But we do the best that we can, and this guidance is very helpful. I think many of us in times past would think, well, if our client produces a video of some bad behavior on the part of someone else, so it's kind of a slam dunk because it's indisputable evidence. Well, that's really not the case anymore. What the president did note is that this is not a new issue, and cited the Transparency Project's guidance on parents recording social workers, which all of you are probably familiar with. And in fact, the guidance that we're talking about provides some, in appendices, some sample documents which may be useful when there is agreement by professionals that parents can record them. could I have the next slide, please? So the guidance focuses on three scenarios. The first scenario is parents recording professionals. The second scenario is parents recording each other. And the last scenario is parents recording children. So firstly, to look at parents recording professionals, well, why do they do this? Many parents distrust professionals, particularly social workers, very much. And it is a rare case where a parent doesn't pop up and say, when taken to notes of a meeting that they attended or a case note of some interaction they had with a professional, they'll say, well, that's not right. It didn't happen that way. Or what they didn't say in the note was this. And so parents will often want to record professionals to give them a basis for challenging things that they don't agree in official records and reports. CAFCAS have guidance on guardians, family court advisors, where a parent says, I want to record this. Generally, CAFCAS are positive about that possibility. And it is their documents, NAGALROs, the National Association of Guardian Ad Litems and Reporting Officers, who produce the sort of template documents for professionals to use with parents to make agreements about how recordings can be made, what they can be used for, and so on. Local authorities, in my experience, take a different view. Local authorities often are not happy about social workers or other social work professionals being recorded. And generally, local authorities will have their own policies, which it may be sensible to look at if a parent says to you, well, I've recorded a meeting with a professional, or if they say, I'm planning to do that, then go on to that local authority's website and see if you can find what their policy is in relation to that. My experience is that most social workers feel that recording them is undermining of the professional working relationships with parents. And the guidance also mentions the British Psychological Society, which has guidance on recording of neuropsychological testing for medical legal reports. Neuropsychology is a very specific type of psychological assessment, usually used in, for instance, people with brain injuries or other neurological problems. But there is research evidence that suggests that recording in those circumstances undermine the validity of the testing. And you can understand that generally, when people know they are being recorded, if they themselves are doing the recording, then what they say, how they respond, may be different from what they would do otherwise. If I could have the next slide, please. So here's an example of a case where, a reported case, where there was extensive recording of professionals. This is a case from January of this year, so before the guidance that we're discussing came out, but the draft guidance was actually published in 2022. And the consultation process and then the publishing of the final guidance took another 3 years. So it all moves very slowly. But in this case, which was a parent, a mother who was alleged to, and indeed found to have fabricated and exaggerated the illness of one of her children, the mother sought to rely on covert recordings of professionals, including school staff, residential staff, and social workers. She also covertly recorded handovers of contact with another parent, just because she didn't want to be misconstrued or misinterpreted. Mrs. Justice Leven considered all of the mother's evidence in relation to her reasons for these various recordings of professionals, and she conceded that that there are often many reasons for recording professionals, including mistrust. Some parents say, well, I'm just not very good at retaining information, and we know that's true. And they may say that they do it for that reason, though of course they could tell the professionals that they're recording for that reason and seek consent. And the judge found that these recordings sabotaged and undermined relationships with professionals, and that led to a finding of significant emotional harm to the children based on those covert recordings. What that mother found, and what we'll come back to again and again, I think, in discussing covert recordings, is that recordings don't often evidence what the parents presenting them as evidence think that they evidence. Often there are unintended consequences of putting that evidence forward, and it is the recording parent who ends up looking worse than the person who's recorded. Could I have the next slide, please? So the next scenario that the guidance considers is parents recording each other. This we often see, very often see in private children's cases, also in public law. And we know when there were disputes between parents, very often there's no corroborating evidence whatsoever. We comb police records, social service records, and other sources of information for anything that might corroborate what our clients say. And to parents, very often the only way that they can provide corroborating evidence is to record what they say, or what they believe is going on. And so it can be very useful and powerful evidence. And I'm sure most of us have had cases where parents recording each other has turned out to be a pivotal piece of evidence in findings in a case. But on the other hand, the guidance tells us that in some cases, recording is a form of surveillance that itself can be an example of distorted and obsessive thinking. That's a strong phrase, and that behavior can constitute a form of harassment, or be controlling or abusive. I think we have a much better understanding now of how that might be. The implications of this invasion of privacy has been held by the court to be highly relevant to the welfare determination. I have a fear I may have frozen.
And William, I think you did, but it slowly then caught up with yourself. So I think we heard everything you said. It just was very fast.
Thank you for that. So the welfare determination can be influenced by a parent's behavior in terms of recording. And that's more obvious when parents covertly record children. But really, I think the concern here is that parents lose sight of what's going on for the child, and how their behavior in carrying out covert recordings may have an impact on their ability to focus on the child and put the child first. Could I have the next slide, please? So here's an example. Come very when I talked a bit later about admitting into recordings. Something you need to know about in order to establish legal tests, but rather just to look in practice about how these can play out. So this stage, which I had to think about, I think it's the same as stranding. I think stranding is a term for transnational marriage, but this was a Court of Appeal judgment from an appeal from a first instance judgment by Mr. Justice Trowell from August of this year. So post the guidance. Interestingly, this case, like most of the cases that I viewed since May, which dealt with covert recordings, doesn't even mention the guidance. So one's never quite sure whether that's because it wasn't before the court. It'd be highly unlikely that a High Court judge wouldn't be aware of the guidance or the silks involved in cases. Or perhaps it's just a matter that with Family Justice Council guidance, it's not strictly speaking a precedent. These guidelines are not statutorily binding, but they do carry weight and are very important. They, as I said, these guidelines came at the instigation of one president of the family court, and the current president wrote the foreword and explicitly approves these lines we're discussing. But in this case, as children transnational marriage abandonment, it was a case where there were allegations between the parents against each other of domestic abuse. The judge found that both of the parents had been abusive towards the other, and the mother appealed. The father didn't appeal the findings against him. At the first instance court hearing, the video recordings that were made by the father and relied on him for the mother's abusive behavior were challenged, as you'd expect, as being selective, possibly edited, a form of harassment and likely abuses of the children, all of which the judge took into account, but still used the videos to support a finding of domestic abuse against the mother. And the Court of Appeal concluded that in the circumstances, that was the wrong decision, that Trial J had given improper weight to the recording, had not considered the circumstances in which that recording had been made sufficiently, and in fact took the view that the recording could tell the court very little about how the mother would have behaved, and the findings based on the recordings were overturned. If I could have the next slide, please. But another case, again, this is an appeal from a first instance decision from a circuit judge, and Hayden J., in refusing permission to appeal, cited the words of the first instance judge, really setting out the difficulties that arise whenever there are covert recordings. One person knows that there is a recording going on and the other one doesn't, and so that person who's making the recording can modify their behavior. They can instigate or provoke the person who doesn't know they're being recorded, and also the obvious points that recordings can be edited, selectively chosen to paint the other person in a negative light. So the court always has to treat the reliability of covert recordings with caution. Next slide, please. It all sounds like a bit of a can of worms using covert recordings rather than the slam dunk that we used to think covert recordings provided. Well, when we get to children, it becomes even more complicated to rely on such recordings. The guidance tells us that covert recordings of children give rise to considerations, including the implications for the ability of the parties to promote and protect the welfare of the family. So very, in my words, very starkly, is it emotional abuse of children to covertly record them? I think we've all had clients who practice in public children's law, clients who go along to supervise contact in the contact center, and they want to take photos and videos of every mark, every tiny bruise or scab that their child has, because they're concerned about the care that the child is receiving in foster care. And we can see, most professionals can see that could easily be seen as a form of emotional abuse of a child. But covert recording of one's own child in some circumstances may also be emotionally abusive. So, for instance, when the child is with another parent or having a video call with another parent, and one parent decides to surreptitiously record that to evidence whatever they say might be going wrong, is that emotional abuse? The guidance highlights the rights of the child in those circumstances. Well, doesn't the child have a right to private and family life, to have a meaningful relationship with the other parent? And doesn't the covertly recording parent, are they not in danger of breaching that right? There are a number of other considerations. I mean, obviously, when we talk about the rights of the child, we also have to consider their age. We have to consider their level of understanding. Is it different covertly recording a very young child as opposed to a teenager? Well, those are two very stark age ranges, but what about children in the middle? There's an enormous gray area here relating to the rights of the child. There is very little one can see in the case law about how those factors would play out in a particular case regarding recording of children. But the guidance raises other factors that crop up where we have covert recording of children. For instance, the potential need for representation of a child. If we have a question about the rights of the child, well, how does the court answer that question? How does the court take into account what would be the child's viewpoint? The guidance seems to imply that in those sorts of circumstances, there is a strong argument for a guardian being appointed for children for that very reason. Also, if a child's right to privacy and right to family life have potentially been breached by a child, how or when or whether indeed at all a child should be informed that they have been the subject of covert recording by a parent is something that the court is likely to need an independent welfare view about. So again, that may necessitate the appointing of a guardian. And if a child is recorded saying something that and the content of what the child says is relied upon to try and prove an allegation. For instance, a child saying, yes, mum hit me, mum smacked me. Obviously, there are all sorts of questions about how that conversation was set up, whether they were asked questions in an appropriate way. But also the guidance points out, well, it might be necessary, subject to all the usual considerations about children giving evidence, to consider whether a child needs to give evidence about a covert recording of something that they said, to really test what the child has said in that video. So a very big can of worms indeed. Next slide, please. The guidance goes into what I would respectfully refer to as a bit of a rabbit hole when it comes to the lawfulness of making covert recordings. There are lots of strands and question marks raised in the guidance. The guidance really isn't in a position to resolve the question of lawfulness or otherwise in any particular set of situations. But there is an important distinction between the making of recordings by parents, which might be lawful, but as opposed to the circulating or publishing of recordings. If you're going to circulate recordings even to social workers, professionals, other parties, etc., that potentially moves the recordings into a different set of questions with regard to lawfulness. And obviously publishing such recordings is even more problematic. But the last bullet point on this slide, I think, is going to be the most obvious and relevant to many of us in our practices, recording as harassment, because it it can be a form of control, it can be a form of coercion. If it's covert and the other person doesn't know about it, 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 it could be argued that that is less so. But as soon as those anyone tries to use those recordings for any purpose, then it becomes clear that the question of harassment is one that needs to be looked at very carefully. Could I have the next slide, please? So I'm going to talk quite a lot about the admissibility of covert recordings. And it will be obvious as we go through that what relates to admissibility, which is arguably the first question that the court needs to determine in relation to such recordings before it gets to how much weight it should put on those recordings in light of all the other evidence in the case, the factors relating to admissibility in the first place and weight overlap to a very great degree. So with regard to the admissibility of any evidence, the first questions are relevance and probative value. I love to make submissions about relative and probative value. Those arguments need to take in so many factors, it's that's really the heart of admissibility. But there are lots of other factors that the court has to consider when determining admissibility. The guidance points out that any recording is likely to be hearsay evidence because hearsay is a statement made otherwise than by a person while giving oral evidence. So if there's just as a statement where there's a written statement where there's no one to answer questions about it, or a police record is hearsay evidence, recordings are hearsay evidence. But as with other forms of hearsay, they're generally admissible if it relates to the welfare of children. In terms of admissibility of covert recordings, my advice would generally be to make a C2 application and for the evidence to be admitted so that it is fairly and squarely on the court's radar as soon as the existence of these recordings and in your client's view, or hopefully in your professional view, they are relevant and probative, that matters fairly and squarely before the court, and include within that C2 application notice that it is hearsay, just for completeness. Could I have the next slide, please? So in determining admissibility, it's not necessarily going to be something that a court is in any position to deal with at the first hearing on which the existence of these covert recordings come up. The court is very likely to need to give directions. It may be that the admissibility is not opposed by the covertly recorded party, probably because they think that it shows the recorder in a really terrible light, which these recordings sometimes do. But the court will need to consider admissibility. First of all, whether transcripts are required, whether there need to be statements about how the recordings came into existence, what it said they show, what it said that they go to, and other factors such as why they were made covertly, what was the rationale for that, and whether it was justifiable. Directions may also need to be given about authenticity of recordings. And when I said earlier that the law is generally behind the technology, this is the crux of that matter, which I'll explore in a little bit more detail. But really, if a party says that I don't think that's a genuine recording, either it's a deep fake, which is a very complex level of forensic analysis required to establish that, or whether they just think it's edited, shortened, cut off, selectively chosen. It may be necessary to instruct an expert to examine the recordings, the original recordings, the recording devices. There needs to be a Part 25 application for that. Again, establishing the probative value of the recordings, that's something that we might need statements about, and considering the implications for the welfare of the parties and the child who are the subject of such recordings. I don't deal explicitly in this talk, although the guidance mentions it in passing in a way, the use of intimate images in court proceedings. There is a case which the guidance refers to, I think it's called REM, and there's a quotation from that in an appendix to the guidance. But really, if there are implications of that go directly to the welfare or safety of someone depicted in those videos, that needs to be flagged up at a very early stage and goes to whether it should be admissible. And then costs. And I have to tell you from my personal experience, the costs of putting forward videos, covertly recorded videos, where there is a dispute about authenticity, the costs can be very significant indeed. And likely, if there's any dispute about admissibility, there's going to need to be an additional hearing to determine that issue. Could I have the next slide, please? This is just a reference to the court's power to control admissibility of otherwise admissible evidence, to exclude it, or to admit anything that might generally be excludable if the court thinks it is appropriate to do so. It's a very wide discretion, and judges can really limit the evidence before it and the uses to which that evidence is put. Could I have the next slide, please? So we're talking about children's proceedings, and again, to talk about the lawfulness. The guidance says, well, that's a question that goes directly to the admissibility of evidence, and again, in my view, the guidance goes down a bit of a rabbit hole here, because it gives examples from other jurisdictions about how those jurisdictions deal with unlawfully obtained evidence. For instance, employment proceedings, financial remedy proceedings. But in my view, if the recordings in question genuinely relate to child welfare, then they are likely to be relevant and probative, whether they were lawful or not. My personal view is that they are likely to be admissible for that reason. Could I have the next slide, please? So to speak a little bit more explicitly about the authenticity of recordings, obviously recordings can be carefully edited. I'll talk about a case in a moment where that the fact that they were obviously edited was important to a judge's conclusion about what findings could be made about a video. But the much more difficult area is where it's alleged that recordings are generated through through artificial intelligence. And I don't know how to do it. I don't know how to make deep fake videos. One goes online and it's said to be really easy. Well, if one knows how to use those sorts of AI applications, then maybe it is. And it's getting easier and easier, particularly as in one case I'm aware of where a home surveillance system has hours and hours of recordings of someone. If you have that level of information data depicting someone, then it becomes much easier, I think. But particularly with audio recordings, where you have some audio recordings of a person, it apparently, I say not from personal experience of making such recordings, it's very easy to fake a recording. So that means there's going to need to be forensics examination of such recordings. My own experience is that what you get from these experts is highly technical and very difficult to understand, even by people who are much brighter than I am. If we can have the next slide, please. So when making your Part 25 application, the guidance points out a number of factors that need to be considered. As I think I said earlier, ideally, particularly when dealing with allegations of deep fake technology, it will be important for the experts to have the original recordings and or the recording devices on which the recordings were made. Could I have the next slide, please? And here's a case example that I referred to. This case, a child abduction from Pakistan, which was published not very long ago, is post the guidance. It featured our very own Anna Hefford, who is an esteemed colleague within the Garden Court family law team. She was second junior for the Guardian in that case. And she told me that the technical report in that, the forensic technical report in that case was very difficult to understand. The Silks instructed in that case had trouble making sense of it. The judge struggled to understand parts of it. It was a very complicated case, factually complicated. And again, that is something to stress here, that all of these cases will depend on their facts. It is like in Laura's presentation on withholding information about care proceedings to fathers, not something where there's a set test, but rather a balancing exercise of many factors. In this particular case, the sections of the report cited by the judge were very conditional. So the experts would say, well, if this is the original recording, then this result is more probable. So the experts aren't going to give you, at least it seems unlikely that they're going to give you black and white answers about whether something's fake or not. They're going to give you relative probabilities based on various possibilities. And in this case, the court considered a range of evidential matters in determining the weight to be given to the videos, and it was important for the judge certainly spent a lot of time on the fact that the mother in that case gave evidence about how the video came into her possession, which the judge frankly didn't believe. And if I could have the next slide, please. And the judge concluded, oh, there's a typo. The judge concluded that he couldn't safely make any findings about the covertly recorded video, and determined that the mother's case, that the father, who was shown in a video allegedly having allegedly sexually abusing a young teenage girl, the court couldn't conclude that the man shown in the video was the father. And as I suggested, the fact that the video, the experts identified that the video contained time splicing, the judge thought that was highly suspicious and increases the chances that it may have been altered in other ways, which the forensic analysis was unable to detect. Now that in itself is an interesting finding. It's almost a no smoke without fire conclusion. But I will move on. Could I have the next slide, please? So I'm running out of time. We want to have a little bit of time for Q&A. So just to note that if authenticity is in question, the burden of proof is on the person seeking to rely on that video. So that is an important thing to note, and may be difficult to prove when it's called into question. If I could have the next slide, please. So the unintended consequences of putting forward covertly recorded videos are massive. I've already referred to recording showing the recorder in a worse light than the recorded person. That's not only the fact that they are covertly recording and the implications of that for what kind of person they are, or what kind of parent they might be, but also if they appear in that video as well, then clients sometimes overlook their own behavior when focusing on the bad behavior of the other parent. And sometimes their own behavior in those videos shows them in a very bad light. The cost consequences I've already mentioned, but the guidance refers to satellite litigation. So in other words, if the recording was made unlawfully, that may give the unlawfully recorded person the grounds to make a civil claim or a criminal complaint, for instance, for harassment. And my very strong view is that lay clients need robust advice at a very early stage before such videos are put into evidence or notified to professionals. It makes sense that they understand all the possible consequences of what they intend to put forward. If I could have the next slide, please. So finally, the guidance gives some advice on how professionals should respond to covert recordings. And if there are any local authority lawyers out there, this is particularly relevant to you. Even if there aren't proceedings, if a parent offers a social worker covert recordings before even looking at them, the guidance says that the social worker or other professionals should seek legal advice about that recording. And before they're viewed, someone should have a conversation with the parent saying, just want you to understand that if you put this forward, it may not show what you think it does. It may be challenged. It may be used for purposes you don't foresee. And even within proceedings, before professionals view covert recordings provided by professionals, there may need to be case management decisions first. And the guidance says that they should not generally be viewed until the court has decided they are admissible. In my personal view, if they potentially go directly to the safety of children, then I think social workers will have no choice but to view them. But if children are safely in foster care, then there's unlikely to be any rush to do that. So that is the end of my talk. Thank you very much for listening. And most of you have actually stayed for the full length of this presentation, so that makes us very happy. Thank you for doing that. And I'll turn over to James for Q&A.
Thank you both, William and Nora. That's both highly detailed and thought kind of provoking, especially in respect of the day and age now of how easily things are recorded. I'm waiting to see if there's any questions, but kind of one case I remember in Poynter is a parent said, here's a photo showing this incident happened. And the simple way to check it is, can I have the image information that most mobile phones now produce? And was shown actually the photo was taken 10 days after the incident and was kind of a staged event. So when that was highlighted to the other side solicitor, quite easily got rid of it. But as I think both were saying, it's kind of understanding the technicalities as much as we can and trying to get as much information from our clients. And when doing so, I don't think, because I think, look, William and Laura, you must have covered every question anyone might have had in respect of these two areas, or they have so many questions that they will be coming to speak to on other occasions. But if there aren't any questions from anyone, and they have to be put into the Q&A, because how this system works is, I take this opportunity to say thanks again to both William and Laura and everyone attending.